Diddy is asking to be released from jail for the third time. And when I tell you that the prosecutors are not having it, they are spilling tea in these documents, letting us know what Diddy has been doing while he has been in jail as to why they think he should not get out. Now, before we get into that, we do have some updates from yesterday's hearing. We did cover the ex parte hearing that Diddy filed saying that the prosecutor was violating his attorney-client privilege and his work product privilege for taking some documents that were in his jail cell. And the order has finally come out from the judge. And the judge also caught some shisty stuff that the defense attorney is potentially doing. So I'm going to update y'all on that. And then we're going to go ahead and jump into why Diddy is saying that he should be released on bail. And then why the prosecution says that Diddy is still a bad boy, just like they said last night, that Diddy is a bad boy, and the reasons why he should not be let out. If you have been watching the last couple of live streams, you know that we are going to be covering the chats at the end of the live stream. So feel free to make sure that you're commenting throughout the live. We'll address it at the end. And if you're watching on the replay, go ahead and leave a comment and let me know your thoughts on the case. So we'll jump right into the updates on the orders from the ex parte hearing yesterday. Let's get my bossy bean. All right. So we covered the ex parte hearing yesterday where Diddy said that the prosecution was violating his attorney-client privilege and that they were also violating his work product privilege because they took some notes that was in his on his bunk. The prosecution says that it was on his bunk. The defense says that it was in a locker, and then the defense contradicts himself in their own brief as to why he should get bond, but we'll get into that in a little bit of how they contradicted themselves. And the court basically said that the prosecution cannot use any information that could be considered privilege or any information from the photos that was taken of the jail cell in regards until the court decides whether or not they're going to determine that this, or whether they're going to decide that this is attorney-client privilege and shouldn't be used by the prosecution, or if it's not attorney-client privilege and can be basically given it back to the prosecution. So the only thing that was ordered is that the defense and the prosecution do a briefing schedule to let the court know what case law they're relying on as to whether they think that the information is attorney-client privilege and work product privilege. Now, as we know, the defense's rebuttal was filed before the hearing, but the court did not have enough opportunity to review the response or the rebuttal brief of the defense prior to having the hearing on the oral arguments. And now what is interesting about the court finally reviewing, so they made their order saying that, okay, prosecution, you cannot use this information until we decide that it's whether or not it's attorney-client privilege. But also we are looking at the defense's rebuttal. And defense, why is it that in your rebuttal, let me go ahead and bullet up, where'd it go? Defense, why in your rebuttal do you not mention something that you mentioned during the hearing? So let's go ahead and take a look at it. The defense is doing something sneaky and the judge does not like it. And we kind of felt like the fire was on the prosecution yesterday. Why are you guys taking this stuff? You got to let us know if it's attorney-client privilege, blah, blah, blah. Now, that was one order. The second order from today is going after the defense for doing something that I think is a little bit shicey, but y'all for sure let me know in the comments whether you think that it is shicey, or in the chat whether you think that is shicey. And I got to add it to the stage. Here we go. So the court says in his November 19, 2024 letter to the court filed prior to the hearing that same day, defendant stated that a government investigator took photographs of several items, including intact pages from 2 different legal pads, and ripped out pages of other legal pads on the docket 75. That's the one that we covered yesterday. The letter also described the legal pads in detail and argued that they were privileged in part because on top of his legal pad and notes, defendant has a folder marked as legal. And this is where we're going to start getting into the contradictory. Remember, we really sparsed that out. In the defense, they said the investigator should have known that this was related to Diddy's case because it had a folder on top that said legal. Didn't mention the words legal being written anywhere else, All it does is mention that it did mention the defense attorney's names here and there, but it did not say that legal was designated on any other document, on any other page, only on the folder that was supposed to be on top of all of the notepads in a locker. That is what the defense said. And the court says, ha ha ha, don't get it all twisted here. So the folder was marked as legal, which put anyone on notice that everything along with the folder marked legal is attorney-client material at the November 19th, 2024 hearing. So this is present in the hearing that we don't get to watch because there's no cameras in the courtroom. During the hearing, the defense attorney stated that the legal label on this and other pads showed that they were clearly protected by attorney-client privilege and should not be in the government's possession. The court notes that the sealed exhibit to the government's brief includes photographs of 2 intact legal pads taken at the time of the BOP sweep. There is no writing on the binding of either pad. At the scheduled hearing on Friday, November 22nd, 2024, defense counsel should be prepared to give the court further context on the legal label that the court was presented with at the November 19, 2024 hearing to address why this label doesn't appear on the photographs in the court's possession and why it wasn't addressed in the defendant's submission to the court made a few hours before the November 19th hearing. Now, what is the court saying? Are you presenting fraudulent evidence to the court, defense counsel? Is that what you're doing? We know he loves some absolute language. So are you absolutely and clearly presenting fake evidence to the court? The court is basically saying there are pictures from the BOP investigation. On those pictures, which the defense described each document and what it was, and if it was intact, and if it was a ripped out page, and blah, blah, blah. They explained that in detail. We didn't go over it yesterday, but I did mention that they explained it in detail. On those photographs, where the court can clearly see the full illegal pad, it did not have the word legal written on it. But for whatever reason, the notebook that the defense brought into court that day saying, look, Your Honor, it says legal. They should have known that this was attorney-client privilege. They should have known that this was pertaining to the legal case. Look, Your Honor, they had to know it. And the court's like, okay, well, if that's the same legal pad that was taken a picture of, why is it not in the picture? And one thing to note, when we're redacting things, we can't redact it out in white. It has to be redacted out in something that you can clearly see that something was redacted. And that's why as we go through these documents, you're going to see things redacted out in bolded black, because we can't just make it like if it's a white picture, a white page, we can't just make it white so that you can't tell and draw the lines back on there so that you can't tell. You have to make it abundantly clear that this is something that's redacted. So the court is probably assuming this was not redacted, but that the defense brought this notepad into the court and wrote legal on it or put a stamp or whatever they use to have legal on the document. They put that on before the hearing, which is basically falsifying evidence to basically try to bolster their case and say that the prosecution knew that they were doing something wrong. And in addition to you bringing this in and it not being on the pictures, you also don't note it in your brief, which we talked about. They went into very deep detail of why we should have known, or why the prosecution should have known that this was attorney-client privilege. They went into great detail. There was a folder. It was on top. Why did you not mention that label of legal on the document as well? So I think the defense has gotten caught up in some mess. Y'all let me know what y'all think about it. We're going to jump right into the request for the bail hearing and talk about why the defense is asking for their third bail hearing. Again, make sure y'all are leaving y'all comments. If y'all are here watching live or on the replay, make sure you hit the like button because it does help us out in the algorithm and get more friends. And if you're not subscribed and you're new here, make sure that you subscribe. Let's go ahead and jump right into the next part of the live stream. So now we are going to be talking about Diddy's request. He filed this back on November 8th. We have not covered it on this channel. I don't know if anyone else has covered this. And when I'm saying anyone else, whether the other legal commentators have covered this, but Diddy is saying that he should be released. One, probably because there's a new judge and he wants to see if he can convince this judge although he has already been turned down by 2 judges already. And 2, he's claiming that there's new evidence. Now, the new evidence that's received, I don't know what it is. If y'all can figure out what the new evidence is, please let me know as we go through it. But they are requesting another bail hearing, essentially asking to be released until the court goes, or the case goes to trial. And when I tell y'all that the prosecution, I was kind of against them yesterday, but the prosecution snapped back in this response. They sure did, but we're going to start with the request first. And I said yesterday that the defense was supposed to turn in their rebuttal today, but the court did give them an extension until tomorrow. So I don't know what their rebuttal is going to be. So we're going to cover the request, and then we're going to cover the response from the state. And then maybe tomorrow, if it comes out on time for the live stream, we'll cover the rebuttal to the state's response from the defense. So let's go ahead and jump right into that. If I can find the goddamn, if I can find the goddamn document that we're supposed to be looking at, that is not it. We are looking for this one. Okay. So this is a renewed request for bond submitted by Diddy, and they give us a little brief introduction on why they are requesting this, why they think that it's necessary at this time. So Mr. Sean Combs, through his counsel, renews his motion for release pending trial. This renewed motion is based on a significant updated proposed bail package, new evidence, as well as changed circumstances regarding Mr. Combs' ability to prepare for trial while detained. And y'all let me know, really let me know, when we go over this bail package that they're offering, what has really changed? What has really changed? I don't think it's that big of a change given what Diddy has been doing in jail, according to the prosecution, and given what he did to get himself into jail. Okay. First, Mr. Combs proposes an updated bail package that is far more robust than the previous proposal, as well as other bail packages routinely approved by courts in this circuit. The proposed package even surpasses a bail package recently requested by the government in a comparable case in a neighboring district. The updated proposed conditions, which include home detention with strict 24/7 security monitoring arrangement, and near total restriction to Mr. Combs' ability to contact individuals other than counsel, will reasonably assure the appearance of Mr. Combs as required and the safety of any other person in the community. And before we get into the bail list, y'all, he still has his plane. I'm just going to throw that out there. He still has his plan. So he is telling us that this plan is going to work. And when y'all get into the prosecution and see what he has been doing in the jail, why would we believe, and I'm on the state side on this one, why would we believe that Diddy is going to follow any rules? We talked about it a little bit yesterday. Apparently he's been doing 3-way calls and, just violating all the rules of the BOP, or the whatever the jail is called. I'm calling it the BOP, but it's whatever, the MDC or whatever it is. He's violating all of those rules, but he wants us to believe that he's not going to contact other people when he's in the comfort of his own home. Yes, he is requesting to go back to that Miami house. He is requesting to go back there. So let's see. Second, new evidence received in discovery from the government undermines the primary basis on which the government initially sought and Judge Carter ordered detention. The evidence made clear that the government case is thin. It confirms the defense initial description of the events depicted in the March 2016 video recording. The video is not evidence of a coerced freak-off, but rather a minute-long glimpse into a complex but decade-long consensual relationship between Mr. Combs and victim one. Now, if you guys have not seen that video, the video entails Diddy dragging Cassie down the hall, throwing a vase at her, kicking her, and I don't think any of that is consensual. She's trying to run away, and you're dragging her back into the hotel room. Then you beat her up in the hallway. Then you paid $50,000 to get rid of the video. And they didn't do a good job getting rid of the video, but nonetheless, you paid $50,000 to get rid of it. And for you as a defense attorney to I forget the word. It was just in my head. But you are putting this out as if this was a consensual relationship. And I don't know about anyone else, but my consensual relationship is not getting drugged down the hall, beat, got a vase thrown at me and kicked. Okay? We didn't say it was evidence of a freak off. We said it's evidence of you being violent. And you're calling it a consensual relationship. It makes absolutely no sense. Additionally, the new evidence refutes the government's proffer at the initial hearing regarding a potential second alleged victim, and the new evidence confirms that the government's obstruction and witness tampering allegations at the initial bail hearing lacked a factual basis. Third, Mr. Combs' current conditions of confinement infringe on his constitutional right to participate in his defense. Given the government's amended estimate of the amount of discovery in the case and its unique format, including voluminous video and photographic evidence, Mr. Combs' release on the proposed conditions is necessary so that he can review the discovery and prepare for trial. Despite the MDC's best efforts to facilitate the defense team's need, the current arrangement makes trial preparation impossible, as evidenced by the recent multi-agency sweep of the facility and resulting lockdown. The Bail Reform Act and the Constitution demands more. Accordingly, Mr. Combs moves to reopen the prior detention decision and request release on the proposed updated conditions. And so they go on to give the court's authority that they can reopen and consideration for bail. So if you guys are new to the case, or if you just need a refresher, Diddy asked for bail once he got in jail so that he could be released. The first judge said no. And then Diddy asked again when the case got they appealed that bail determination and the case got reassigned to a different judge. And that judge also said no, that Diddy is a danger and that the proposed bail conditions would not be enough to ensure the safety of the community, ensure the safety of victims and witnesses, because, he's a bad boy, as consistent with his record label. And so they go in to say that the court has authority to reconsider bail, and that is what they're asking them to do. Now, do they use the best laws to support that? Maybe not the best, but we're not going to dive into that part. We want to get into the meat and potatoes of what Diddy thinks is a proper conditions for release versus the other two that we received before, which I'm going to say is pretty similar to the first two. So let me know if y'all spot any differences in the proposed conditions that they are suggesting in order to release him on this third request to be released on bail. So this is the updated proposed conditions for release. The defense proposes the following updated bail package, which will assuage any concerns of danger and obstruction and will ensure Mr. Combs' appearance in court. They are still sticking with the $50 million bond. He cannot get over that $50 million. He's like, that's all I got. That's all I'm offering. Every single bail proposal has offered this $50 million, like every single one. And then he said, co-signed by Mr. Combs. He's putting his mother into it, his sister, the mother of his oldest daughter, the mother of his youngest daughter, and his 3 adult sons. So he's making all of his family members be tied to his mess. Now, if my daddy was in jail for sex trafficking people, I'm sorry, I would not be signing off on your bail package. I absolutely not. Absolutely not. I'm not signing on to that bail package, but good kids for him, because a lot of the kids are actually signing on, or I guess the adult kids are signing on, and then his baby mamas. And yeah, I wouldn't sign on for my daddy. If I was your baby mama, I for sure wouldn't sign on for you either. But, love is love. Secured by the equity of Mr. Combs' resident located in Miami, Florida, an unencumbered property appraised at about $48 million. This is the house that he paid off, I think, like $18 million in order for it to be unencumbered, meaning that he doesn't owe anything on the loan. Now, he is also offering this house to basically be secure his $50 million bond. So he's not going to give the court $50 million. He's securing it with his home that he wants the court to allow him to go and live in. The one that he did all the freak offs and had all the cameras and everything. He wants to be able to go to that home, but also secure his bond with the home, which in my opinion is ridiculous. But hey, I'm not a criminal attorney, so don't quote me on none of this. Okay, so next he wants to further secure his $50 million bond by the equity in Mr. Combs' mother home in Miami, Florida. And so I don't know. I mean, I guess his mom is signing on that she's going to put her house up for him. Yeah, I'm not doing that. I think his mom is like 86 years old. If I read it in this, like 86 years old. Why are you putting that lady's house on the line? Like, I get he may have paid for the house, but come on, Diddy. Come on, leave your mama alone. Leave her alone. Full home. The second part of the conditions is full home detention at his residence in Miami or at a suitable location in New York with GPS monitoring. So he wants to live in the house that he's securing the bond with. in Florida. This case is in New York. So he's saving money by going to live in his house, which people can access, and we don't know which secret interests he has or anything of that nature. With him living in the house, counsel will travel to this location for any in-person meetings with Mr. Combs or have counsel meeting via video. So Combs will just stay in the house. He doesn't have to travel back and forth to the attorney's office. To the extent Mr. Combs' travel is necessary to attend court or pre-approved medical appointments, his travel will be restricted to the Southern and Eastern District of New York and the Southern District of Florida. Remember, he was saying he needed a doctor because he was allegedly withdrawing from drugs, but he's basically saying that he'll stick to only traveling within those three parts of the country. And then Mr. Combs must pay all or part of the cost of the location monitoring. So they're going to get into the monitoring that they're suggesting now. 24/7 monitoring by qualified security personnel approved by the government and pretrial services. I believe this is new, that he wants security to basically monitor him. Security, which we have witnessed be a part of his nonsense, right? We have a security guard alleging that he assaulted him, and you're telling me that he's going to hire some type of private security that he's not going to be able to influence. That's a part of the bail package. Mr. Combs will have no access to telephones or internet except for during calls with counsel to be arranged by security personnel. We talked about this a little bit yesterday. They already have restrictions on phones in the jail. He's already breaking the rules 3 different ways. He's sending text messages that he's not supposed to. He's doing 3-way calls where he's not supposed to. And he's also using other people or other prisoners, not prisoners, I guess they're in jail right now waiting trial, but other inmates. So he's using their PIN for the phone so that the government cannot track the calls that he's actually making. But he wants the court to believe, and the prosecution does a good job in pointing this out, he wants the court to believe that if he is allowed to go to his house where he's had all of these freak-off parties and all of this trafficking and everything, if he goes there, which his house is on the water. I saw it when I was in Miami last weekend. So he wants to go to his house on the water where he has a yacht, be monitored by security, and only expect that the court will believe that he will only talk to his attorneys. You're not even doing that in jail. You're not even doing that in jail. And that's the prosecution's argument here. We'll get into it. Next, restrict all visitors except for counsel in pre-approved lists only consisting of specific family members with the consent of pretrial services and the government. Again, he's already violating that in jail. He has a pre-approved list of contacts that he can contact, and he is contacting people beyond that list. Okay. In furtherance of that position, family visits will be scheduled only with pretrial services prior approval, and security personnel will monitor family visits. Again, he has control over his security and has had control over his security for years. Mr. Combs shall avoid contact. Oh, sorry, I'm not showing it to y'all. Next step they think is going to help is that Mr. Combs shall avoid all contact directly or indirectly with any person who is or may be a victim or witness in the investigation of the prosecution. The prosecution is going to go ahead and say that he's already contacting witnesses and victims. So no, we don't think he's going to follow that. Number 7, Mr. Combs will consent to provide pretrial services random access to the residence. Mr. Combs' passport was surrendered to his counsel on April 1st of 2024, which counsel will provide to pretrial services. They already talked about this. He turned in his passport along with the following family members: Janice Combs, Chance Combs, Jesse Combs, and Delilah Combs, which are his kids. And then counsel will continue efforts to sell Mr. Combs' plane. So like I said, he still has an airplane. His house is on the water next to a yacht that he owns. And y'all want me to believe he's not going to escape? He's not planning to escape. Number 10, the defendant shall submit to testing for a prohibited substance. Which prohibited substance? Which one are you talking about? If required by the pretrial service officer or supervising officer, testing may be used with random frequency and may include urine testing, the wearing of a sweat patch, a remote alcohol testing system, and or any form of prohibited substance screening or testing. The defendant must not attempt to obstruct or tamper with the efficiency and accuracy of the prohibited substance screening or testing. So they're saying they're going to drug test him and alcohol test him, and somehow they believe Diddy is not going to be able to get around this. And then Mr. Combs must participate in a program or counseling if directed by pretrial services. So this is only if pretrial tells him to do counseling, that's when he's going to do it. He's not offering it just free of charge, right? And then all other standard conditions of pretrial. This is one thing that they wanted to add in to make sure that the court would not deny their request, because this is what they think is fair. They go on to add, additionally, for the avoidance of any doubt, and as stated during the September 18, 2024 hearing, if Your Honor wants something more or different, we can do whatever Your Honor thinks is necessary regarding the release of conditions. I would just say, like, the last 3 or 4 things that he offered up is only if pretrial services requested. So I don't even think that this proffer is really genuine, to say the least. So he's added some things. He wants to hire his own private monitoring company. And again, he's not saying that he's going to wear an ankle monitor. He's just saying that he's going to hire private security who is somehow going to control Diddy. And like I said, we don't know if he has secret passageways to his house to go underground or anything of that nature. But we're going to trust this random private security company that Diddy's going to be paying for to somehow monitor him, not to put an ankle monitor on him or anything of that nature. Just, we're going to trust these private people to monitor Diddy, one of the largest celebrities in the United States and maybe even in the world, right? Okay. They go on to explain that, let me see here. They go on to explain that these conditions should be sufficient because they have approved similar conditions in other cases, including the one in, let me see, I think it was Jeffries. Yes. Indeed, the government recently successfully requested pretrial release for 2 similarly situated defendants, including a CEO accused of sex trafficking dozens of young men, including through witness intimidation. So they're saying this guy is just like me. He's accused of sex trafficking, but this time men, and he also intimidated witnesses. So are you admitting to it, Diddy? And that's in the Jeffries case. In Jeffries, the government sought release despite claiming the defendants relied on the services of a security company to surveil and intimidate witness, thereby securing their silence. The condition of release requested in Jeffries pale in the comparison in the conditions proposed by Mr. Combs here. There, the government requested bonds of $10 million and $500,000 respectively for the 2 released defendants and release to home detention with GPS monitoring. Like I just said, Diddy didn't even offer GPS monitoring. He only offered a private security company that we don't know who they are and what they're going to be doing. The requested conditions included no additional security or surveillance arrangement whatsoever. Yours do not include GPS surveillance. So yeah, you kind of lose on that one. And so he's basically saying that this guy was released only by doing 10 million, and then his, I guess, co-conspirators were released on 500,000. And he's basically like, why am I not released? Because they're alleging that I threatened witnesses too, and I threatened the victims too, but I'm offering 50 million. So you should definitely let me out. That's his argument. That is his argument. They did the same thing as me, so let me out. It to me sounds like a red herring. They're basically trying to distract the government by saying, look, I'm offering more. Let me out, please. Okay. Let me see. And then they're going to go through like the laws regarding. Okay. I wanted to get to. Sorry, y'all. I'm trying to get to the next part of the stream regarding what they're saying is the new evidence. Okay. So they go on to get into the actual facts. So we're going to go through the facts that they're alleging is the reason why he should be let out on bail. And then we're going to jump into the prosecution's, what do you call it? Position as well. So let's go ahead and jump into the weight of the evidence in light of new evidence. And y'all let me know if this is new evidence in your opinion. Where is it? All right. So they're starting off by saying, over the past 6 weeks, the defense has received 23.5 terabytes of discovery material. The material reveals new information about the case, the evidence, and the government's previous bail condition that was not known to the movement at the time of the hearing. Y'all let me know if it's new. It doesn't sound new to me. The new material demonstrates that the government previously misrepresented the weight of the evidence, and it undermines the government's claim that Mr. Combs presents a danger. Now, they're basically saying that the prosecution argued their point too strong, and the discovery basically doesn't support the prosecution's point. But that's up for the jury to decide whether the evidence is sufficient enough to support the prosecution's case. They have to prove it beyond a reasonable doubt. Diddy is basically trying to adjudicate the evidence by being released on bail. Their evidence is not strong enough, so I should be out on bail. That's his argument. That is literally his argument. For the discovery, it includes that that refute the government core sex trafficking allegations. Second, this new discovery negates the government's claim that at the initial detention hearing that there is a potential second witness. Third, the discovery shows that the government's obstruction and witness tampering allegations are entirely misleading. And finally, the government failed to disclose to the court information concerning Blank's testimony that undermines its claims. We take each in turn. So they're going to explain why all of these are reasons why the court should allow the bail now. But before we get into that, as you guys can see, it's blacked out. This is how you have to black out things. And this is going back to the court pointing out, why do these written pads say legal, but the photos don't say legal? Even if they had been redacted, the court would have been able to tell that they were redacted because this is how we're required to redact things. It has to be visible. So communications with Blank corroborate the defense. And I'm thinking that's going to be, victim one. So communications with Cassie is going to corroborate the defense. So I don't know how, but this is what they're claiming. As noted, the government's allegations of sex trafficking relates to one woman referred to in the indictment as victim one, with whom Mr. Combs shared an 11-year relationship. Included in the discovery materials are all of these things that we don't know what they're telling us is included in the discovery material. But they do explain why they think that victim one, Cassie's communication with Diddy throughout the 11 years, basically negates the fact that he abused her. That's his argument. They were in a relationship for 11 years, so the fact that he beat her up is irrelevant, is what they're trying to tell the court. The first mention of any sex trafficking or unwanted sexual contact involving alleged victim one was in November 2023, 5 years after the couple's 2018 breakup. The evidence shows these allegations were merely attempts to obtain a financial windfall from Mr. Combs. In the spring of 2023, victim one revealed to one or more others that she needed money to support her small family. She told others that she had started writing a book about her relationship with Mr. Combs. In June 2023, she texted Mr. Combs' employee that Mr. Combs should contact his lawyer to have his lawyer contact her lawyer. She followed up on this by a text on June 15, 2023. The same day, her lawyer contacted one of Mr. Combs' lawyers who's expecting that she might make an extortionate demand, recorded the conversation. So they recorded the conversation with Cassie talking about the book deal, essentially. During the approximately 8-minute recorded call, the lawyer confirmed victim one was writing a tell-all type book and that Mr. Combs could buy the exclusive rights to the book for $30 million, which would ensure that it was not published. Mr. Combs and his lawyers considered this an extortionate demand and did not pay the money. In the fall of 2023, victim one pursued a different legal strategy where she basically filed her lawsuit asking for the same amount of money. They also indicate that had she only went forward on the physical abuse claims, she would not have been able to bring the case because of the expired statute of limitations. So she had to add in the sex crime claims in order to have a valid complaint under the Adult Survivors Act. Now, essentially what they're saying is Cassie wasn't abused until he refused to give her $30 million. And now she is claiming that she was abused. However, she also indicated that she is writing a tell-all book and that she, in order to basically protect Diddy's reputation, that she's not going to release it if he, compensates her for the damages that he caused her throughout the relationship. I don't think that in itself, of giving him an opportunity to protect himself prior to releasing the book, in itself will negate the fact that he sexually abused her or that he abused her in any way. He's basically saying that we were in a relationship, so there's no way that I can sex traffic her. It's a dumb argument within in my opinion, and then that so that case quickly settled, basically trying to say that Cassie is not credible because she, in their opinion, tried to extort him for her not to release the book, and instead she went ahead and released the lawsuit. But if that was the case, she could have just went ahead and released the book in general, right? Because I'm pretty sure, remember, that lawsuit settled within 24 hours. I'm pretty sure she was going to release that book, and he decided to pay her instead of allowing her to release that book. The alleged second victim, they're going to go into another contention that the prosecution argued. During the initial bail hearing, the government alluded to a potential second victim, arguing that Mr. Combs' contacts with this purported victim were evidence of obstruction on the September 18th hearing. Despite the government's claim blank that this woman is a sex trafficking victim, the defense has learned that the government has not even spoken to her, nor was she the target of any obstructive conduct by Mr. Combs. The government clearly misled the court and concealed the true facts during the initial bail hearing. For example, the government knew blank. We don't know what they knew. The government also knew blank, that we still don't know what that is, but the conduct was nothing of the sort, which the government clearly knew. Indeed, the discovery confirms. So they basically say that the prosecution painted victim number 2 as a sex trafficking victim, but the prosecution is going to explain why they were calling this person a victim, and it wasn't necessarily under the sex trafficking guide, but under basically like an extortion guide. I'll give you money if you shut up. I won't release your tape if you shut up or if you go on my side. So that's what the prosecution is going to explain. And then their next position as to why this is new evidence. And so mind you, they knew about Cassie and the relationship that they had. Diddy was in a relationship with her. He had communication with her. He didn't need discovery to tell him that Cassie never said that she was a victim of sexual assault until she needed to sell her book. He knew that, right? From the beginning of the case. That's not new evidence. And then in addition to that, for the second victim, they also knew that what he did with this victim. So that's not new evidence. Just because you don't think the evidence is strong enough to support the prosecution's position doesn't mean that it's inaccurate or that it's misleading. They're arguing their point. This is not the time to make the argument that they're making. Next point as why they don't think that this case should go that he should be let out on bail. The government's other obstruction and witness tampering allegations were false. The discovery also undermines the government's argument that Mr. Combs attempted to tamper with other individuals, including a grand jury witness. During the previous bail hearing, the government outlined it. My alarm's going off. Okay. Sorry, y'all. I'm trying to turn off. Oh, it's off. Okay. During the previous bail hearing, the government outlined what it billed as obstructive communications with grand jury witness in June and July of 2024, and further characterized Mr. Combs' September 2024 communication with another person as a witness tampering. Judge Carter considered the government's most persuasive evidence, posing the question to the defense: if he's aware of this April 1, 2024, then again, why is he contacting witnesses in June and July of 2024? And what would be the purpose of Mr. Combs continuing to speak to that witness after September 11th? But the recent discovery now corroborates the defense argument at the initial bail hearing. At that hearing, Mr. Combs' counsel explained that his contacts with these people were not in any way obstructive. One grand jury witness contacted him, not the other way around. The September 2024 communication were with an individual represented by counsel who wanted to make a public statement. And to the extent individuals were contacted, defense counsel explained that to conduct a responsible defense investigation, it must, of course, continue to interview witnesses. So, prosecution basically accused Diddy of contacting witnesses inappropriately. Diddy said, "This is a part of my defense investigation." I can't help it if they... Hello. He said, "This is a part of my defense investigation. I can't help it if these people want to tell their story. Let me construct and help them tell their story." Diddy, you are going on trial for sex trafficking. Like, what makes you think that you should be the spokesperson for these people? What makes you think this? But he's like, I still have to investigate. which was part of the other hearing. He has to be able to talk to people in order to argue his case. He has to be able to talk to those people. Okay. So they go on. In opposing these arguments, the government misled the court and concealed the actual content of the communication. The truth, however, is that the grand jury witness, the one with whom Mr. Combs had not spoken to in several years, said blank. We don't know what they said. I want them to release what they said so bad. These statements, which the government conveniently withheld from the court, in no way evidence obstruction. The same is true of the individual who Combs contacted in September 2024. Again, he's doing his investigation, but somehow these people are coming out with public support statements of him, right? And they're getting paid by him, which we're going to get into with the prosecution's argument. But during its proffer to the court, the government concealed these facts, which completely undermine its claim that the timing of the contacts with the person in September 2024 suggests obstruction. Mr. Combs is entitled to have his counsel conduct a thorough defensive investigation. So we know that they're going to keep messing with people if they let him out. Like this argument is contradictory. He's going to keep messing with people if they let him out, and he's going to put it under the guise of he's only conducting a defense investigation. That's all he's doing. That's going to be the argument. Indeed, his constitutional right to the effective assistance of counsel demands it. At times, counsel might also need Mr. Combs' assistance and involvement to conduct proper investigation. So they're going to include him in the investigation, in the interviews with the witness. And he's going to say, well, this is not witness tampering. I have the opportunity to interview my witnesses that are going to be against me. Here we go, Diddy. Of course, Mr. Combs has a constitutional right to participate in his defense. And if witnesses are contacted to support his defense, that alone does not amount to obstruction or evidence it does not amount to obstruction or evidence any risk of obstruction of danger. So he still wants to interview these people. Testimony of blank undermines the government's case. The defense counsel noted that at the initial hearing that based on defense interviews and investigations, several individuals associated with a male companion agency have stated to the prosecutors that they are paid for their time and not sex. So basically, they're saying that the that the prosecution case is not strong because a lot of these people that they're claiming are sex trafficking victims, they're paid for their time, not sex. So they're not victims. There's no sex trafficking here because these people are just paid for their time. They're escorts. So that's another reason that's new evidence. He's saying, well, they're paid for their time, actually. That's what the discovery showed us. So no, he's not sex trafficking them. Silly prosecution. All right. And then they go on into Diddy's philanthropic behavior. They say that he has a good character, physical and mental condition, family ties, employment, financial resources, length of residence in the community ties, past conduct, history relating to the drug and alcohol abuse, criminal history, and record concerning appearance at the court proceeding. He's saying all of those gives us reason to believe that he's not going to, leave and abandon his case. They go on to talk about his character. They talked about how he worked as an assistant at a music record label, and then he started his own record label, and then he made a hit song. And his character in being a rap mogul is the reason why they think that he shouldn't be released, because he became famous. He has strong ties to the community. He also gave out money to charity. Mind you, if you add up everything that they cite, which they cited before in their previous argument, we're talking about $7 million is what they cite. Now, I'm not one to be counting people's pockets and watching how much money that they give out, right? I'm not one to do that. However, if I'm not, is Diddy not a billionaire? Is Diddy a millionaire or a billionaire? But he gave away $6 million to charity. Mind you, the $6 million is a tax write-off if you're giving it to charity. And that's what I think it would be, right? He helped the Boys and Girls Club. So over the course of, 5-6 years, a little bit longer, he gave away $6 million. And for that, he is philanthropic, and he's not going to run away from this case. Diddy is such a good person, right? Then they go on and say he's not a flight risk because he has a long family relationship. Although Combs never married, he has multiple significant long-term relationships. You mean people he never committed to? He just has kids. So let's go on. These are relevant. He fathered his first child, Justin, who is now 30, with Misa Hilton. He was in a long-term relationship with Kim Porter, who he called the love of his life after her tragic passing from a lobar pneumonia in November 2018, when we're not even going to get into the fact that people think he has something to do with that, okay? I like how y'all put it in there, but people think he has something to do with it. He shares Quincy, who he adopted, Christian, and his twin daughters. Who is the other person then? I thought he said he had like an oldest daughter. If he just has the twin daughters. He fathered his 18-year-old daughter, Chance, with his longtime friend. He had a kid with a friend. All these people that he's not committing to, just people he's popping out children with, right? Chance is now enrolled in a performing arts school, and then now he has a 2-year-old daughter named Love. Again, with the person he hasn't committed to. So do we think that Diddy really want to leave his kids? I think he would, but that's just my opinion. And then Mr. Combs also supports his 83-year-old mother, who recently underwent brain surgery and was in the hospital as recently as this summer with a heart issue. Although Mr. Combs is not his mother's only caregiver, he assists with her medical care. It seems like she's been able to do without him. But he's saying he needs to help his mom, so he's not going to run away. Do we think that he is going to help his mom versus going to jail for life? I don't think so. He's putting his mama's house up for collateral. He done took his mama's passport. He done made her sign off on his bail condition. Do we really think he's not going to run away on her? I think he would. But he wants to stay in town for his kids and his mom. And he wants the court to believe that's the reason why he would not ditch out on this lawsuit for sex trafficking, where he's facing at minimum 15 years. At maximum life is what he's facing. He has access to a boat. He has access to a plane. And you want to tell me he's not going to run away? Yeah. And he wants to go stay in his house. His house. I don't know about that, Diddy. Okay. And then the last part of it, I'm just going to kind of skim over. He basically goes and says that he does not have the adequate opportunity to review the information in the case. As they said, there's 23.5 terabytes of information. Now, I don't know how much that is, but it sounds like a lot because I don't just normally use the word terabyte. That sounds like a lot of bytes, right? And so there's all of this information that they need to go through. He apparently doesn't have a laptop that's adequate to have the information on it. The jail is on lockdown constantly, including that raid that we talked about yesterday. And basically saying that he doesn't have the opportunity to meet and confer with his attorney sufficiently in order to prepare for his defense. Now, if y'all remember, Diddy is the one that wanted a quick and speedy trial, hence why we are going to trial in May of 2024. And now he's saying that he doesn't have enough time to review all of the evidence. Like, Diddy, you knew all that evidence was in your house. You knew how many video recordings you had. You knew how many phone calls or how many phones you had. You knew how many devices you had. You knew it was going to be a lot of information. So to me, how could you then argue that you're not going to have enough time to consult with your attorney and review things? Whatever. So he goes on to say he needs to be released for that reason, and his constitutional right is protected because he has to be able to meet with his counsel and prepare for his defense. The prosecution scrambles that all up. I can't even support that argument that they made. And so that is the end of Diddy asking for bail bond. He wants to get out of jail. Do y'all think that he has provided sufficient information or not sufficient information? Was there any new evidence here? No, there's no new evidence in what he's asking for. He knew about all of this stuff when he argued the first 2 times. Just because they read the evidence and they don't think it's as strong as what the prosecution is saying. And in my opinion, they're definitely twisting the prosecution's position to make themselves sound good on paper, which of course we know some attorneys do, but also you have to be truthful, right? You can definitely put the evidence out there in a way that supports your client more, but you can't outright lie. You outright twisted the prosecution's position. Said that he doesn't have access to a laptop. We'll get into that in the prosecution. So let's go ahead and jump into the prosecution's position as to why they don't think that Diddy should be out on bond. Like I said, if you guys are not like I said, but as a reminder, if you guys are watching live, y'all, there are 73 people watching live and we're only at 23 likes. So if you are watching live, please do hit the like button. Let's see if we can reach a like goal of 75 likes for the live stream, which I feel like we can because we already have 23 likes. So make sure you're going ahead and hitting that. If you're watching on the replay, make sure you also hit the like button because we love the likes from the replay as well. And if you're new here and you're not subscribed, please do subscribe. We cover cases like this all the time. So let's jump into the prosecution's position. And y'all, we are going to be going through the chat at the end of the live stream. So if you got comments, make sure you go ahead and drop it in the chat and we'll get to it towards the end of the live stream. Now we are jumping into the prosecution's position as to why they do not think that Diddy should be able to bail out of jail. And I will have to say that I actually agree with the prosecution today. When you hear about the grimy, shicey things that Diddy has been doing in jail, and then he puts out this bail condition where he wants to be let out. And I know I kind of hinted at it throughout reading the bail position, but he puts this bail position out. And I'm like, you can't even be trusted in jail. You can't even be trusted in jail. Now, does the prosecution potentially look at some things that may or may not have been attorney-client privileges? Maybe the court is going to decide that. But also, is Diddy bribing people? Maybe we're going to go ahead and address that once we jump into the state's response to Diddy's request to be released on bail. And let's pull that up. Come on, computer. There we go. There we go. Let's jump into that. Let's get to the point, Bree. All right. Preliminary statement from the prosecution. They're going to summarize all the reasons why they don't think that Diddy should be out on bail. He's a bad boy. Bad boys for life. Okay. That's what the government is saying about Diddy. All right. The government respectfully submits its opposition to defendant Sean Combs' renewed motion for bail. The defendant's motion should be denied as two judges have already concluded based on the evidence in the record the defendant poses serious risk of danger and obstruction of these proceedings. In seeking a new hearing, the defendant rehashes the same arguments rejected by those two judges with claims of new evidence. I agree with them. There was no new evidence in my opinion. But the defendant offers nothing new and material justifying a third bail hearing. In fact, the only truly new relevant evidence shows that the defendant has continued to engage in a relentless course of obstructive conduct designed to subvert the integrity of these proceedings. As described in detail below, while attempting to evade law enforcement monitoring, the defendant has, among other things, orchestrated social media campaigns that are, in his own words, aimed at tainting the jury pool, made efforts to publicly leak materials he views as helpful to his case, and contacted witnesses through third parties. Now, let me tell y'all, we are just reading these. These are allegations. We don't know if any of this stuff is true, but I will tell you right now, I believe it. I believe the prosecution because I can see Diddy, like, I don't know him personally, of course. I don't know him personally, but I can see Diddy doing the stuff that the prosecution is going to go on to accuse him of doing. And not only do I believe it just because Diddy is who Diddy is, but I also believe it because they got evidence. They got the recorded phone calls, the recorded lines that he knows is being recorded, and he's saying all of this stuff on the phone. Like, do you think they're not monitoring you, Diddy, out of all the people in this high-profile case? Do you really think they're not monitoring you? But yeah, I believe the prosecution wholeheartedly in the stuff that they're going to go on and say that Diddy is doing in these jail cells, okay? He is doing bad things. Okay, for the reasons, the court should deny the defendant a new bail hearing. To the extent the court decides to reopen the bail hearing, however, the defendant's application for bail still must fail under the Bail Reform Act. His motion ignores the significant evidence presented by the government at the prior hearing, showing that the defendant is violent. He is a violent serial abuser who uses his vast wealth and position in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. In light of the well-documented danger posed by the defendant, the updated proposed conditions of release are woefully insufficient to assure the safety of the community and integrity of these proceedings. He's already doing it in jail. He's already doing bad things in jail. Indeed, the defendant's continued obstructive conduct confirms the conclusion reached by the two other courts. No set of conditions can meet that task, because Diddy is going to find a loophole. He's always going to find a loophole. The defendant's request for temporary release should similarly be rejected. The defendant's confinement in the Metropolitan Detention Center of Brooklyn affords him more than adequate opportunity to prepare for trial, and his convenience did not provide a basis to evaluate the danger to the community and the threat of the integrity of these proceedings that the defendant's release poses. And remember, I summarized it, but essentially he was saying that it's too much information and he won't have enough time to go through all of the evidence before the trial date that he set, mind you, the trial date that he set. So they should let him out. And so I think the prosecution is right saying that this is more of him reviewing all the evidence on like his laptop or in the jail or in the conference room. It's inconvenient, and we should let him out because he has money and he can pay for private security. Yeah, they should do that. Okay. So they go on to summarize the arrest and why we are here. And then we get into him being remanded into custody. Let's see here. Okay, sorry, y'all. I went too far. Okay, so he got arrested. He's on for sex trafficking, all of the things. Following the defendant's arraignment on the indictment on September 17th, the government moved for the defendant's detention under the Bail Reform Act. Because the defendant was charged with sex trafficking, detention is presumed under the Bail Reform Act. So he is charged with a serious crime, so it's presumed that he needs to be incarcerated unless he can overcome. He has the burden of proof to overcome the presumption of him staying in jail. After hearing argument, Judge Tarnofsky found the defendant had not rebutted the presumption in favor of detention, and there were no conditions that would reasonably assure the defendant's appearance or the safety of the community. Judge Tarnofsky, we're going to call him Judge T again, emphasize the serious nature and circumstances of the charged conduct, which largely happened behind closed doors and therefore difficult to monitor. So it happened behind closed doors, and he's basically asking to be released behind closed doors in the comfort of his own home. So do we really think that we are going to be able to monitor Diddy? And he's gotten away with this for more than 25 years, more than 30 years he's been doing this. And do we think we're really going to be able to monitor him? I would have to say no. I don't think we're going to be able to monitor him if they let him out of jail. Where were we at here? Okay, Judge T noted indications in Combs' history and characteristics that would present a danger to the community and dismissed as inadequate exhortation from defendant's counsel to trust him and his clients given the defendant's drug abuse and anger issues. So not only has he done all of these other things, he also got drug abuse and anger issues. Judge T highlighted that the weight of the evidence was significant given the multiple witnesses observed firsthand the defendant's violence and coercion. Defendants then appealed Judge T's decision to Judge Carter, to whom the case was then assigned in a bail hearing before Judge Carter proceeded on September 18th. So within 2 days, okay? After a lengthy argument, Judge Carter denied the defendant's bail, finding specifically that the government had proven that the defendant is a danger regarding obstruction of justice and witness tampering by clear and convincing evidence, and that the defendant is a danger to the safety of others in the community, more generally by clear and convincing evidence. Although Judge Carter did not rely on risk of flight, he noted that the bail package proposed by defense counsel was insufficient to address that risk. Ultimately, Judge Carter found that there was no condition or combination of conditions that would reasonably assure the safety of a person in the community, or that the defendant would not obstruct justice or to tamper with the witnesses, and accordingly denied defendant bail. So the prosecution does a good job at pointing out what the other judges are doing. Judges are less likely to deviate from other judges that have reviewed the same information or even more information prior to them. So if one judge ordered that he needs to stay in and there's no bail, the second judge, like we see here, also is going to decide that. I would not be terribly surprised if this third judge also decides that, especially with the new evidence that Diddy is already breaking rules in jail. So I'm pretty confident that they are going to keep him in jail and he's not going to be able to come out on bail. I know some people are saying because of the incident with a potential attorney-client breach situation, I think that the prosecution has way more information, more than enough information beyond the slight piece of evidence that was included in what might be considered attorney-client privilege. They have so much more evidence beyond that they were legally able to collect, hence the recorded calls and the recorded emails. If they're going to anyone other than the attorneys in jail, those things are automatically monitored. I think they have more than enough evidence with that to say he's already breaking rules in jail. He should not be let out, even with the one piece of evidence that they note regarding the notes on the legal pad, according to the defense. And so essentially they say that the defense is basically saying that the court has to renew this de novo and that he's basically entitled to a new bail hearing when he is actually not necessarily entitled to a bail hearing just because there's a new judge on the case. Okay, and then so let's jump into further reasoning as to why the prosecution does not think that Diddy should be let out on bail. Okay, the defendant's motion to reopen the bail hearing should be denied for the simple reason that he has not presented any information that was not known to him at the time of the bail hearing before Judge Carter. I would agree with that. As set forth below, the defendant asserts that the court should reconsider new information relating to the defendant's relationship with victim one and his communications with various witnesses as a basis to reopen the bail hearing. But these allegedly new facts are the same very arguments made by defense counsel and rejected by the district court previously, dressed up with recently produced discovery. So, like we said, they knew all of this information. They got the discovery. They don't think that the discovery supports the information. So they're throwing in bits and pieces of the discovery that they have to say, no, he's not a risk. Or they never even say he's not a risk to the community. They just say he's not going to flee because he has family ties. But they say they use the discovery to say, oh, they said this, but this is not all the way adequate. You're interpreting the discovery differently. That's for the trier of fact, not for the defense to be analyzing on on consideration of whether there's going to be bail enough. So, or bail, or whether or not there's going to be bail. So, because those facts were well known to the defendant before any discovery production, and because the defendant relied upon them in his prior hearing, he cannot recycle them here to revisit the sound determination made by Judge Carter that the defendant is a danger or risk danger and risk to obstruction and must remain detained. The defendant rehashing of the same personal attacks he made against victim one before Judge Carter is not new information. The defendant's claims that communications between defendant and victim one, which were recently produced in discovery as part of defendant's electronic devices and accounts, constitute new material. The defendant claims that the recently produced text messages reveal a loving, at times toxic, long-term relationship between two adults who decided to mutually break up. This claim is nothing new. Defense counsel made these exact points previously and even referred to the text messages as communications. At the September 17th hearing, this is what the defense counsel said. Remember, they're saying this is new information, but the prosecution pulls from the transcripts and says that the defense counsel stated, this is a 10-year relationship. This sex trafficking is a 10-year relationship. These two people were in love. That will be made abundantly clear by the way they speak to each other, by the way other witnesses describe their time together, and by the circumstances of how they broke up. They were in love, but Mr. Combs wasn't always faithful. What that got to do with beating people up? Whether he's faithful or not, you don't get to beat people up because you're not faithful. If anything, it should be the other way around. No, don't put your hands on other people, y'all. But okay, he was not faithful. At the end of the day, there was mutual philandering, and victim one ended up marrying the trainer that Mr. Combs got for her and had 2 children. That signaled the end of the relationship. So he was not faithful, so he beat her up. And it's both of their faults. Like, what kind of argument is that? There is nothing about the content of the text messages between the defendant and victim one that was not known to the defendant at the time of the initial hearing. So remember, defendant is saying this is new information because we just got text messages of the victim, Cassie and Diddy, saying I love you to each other. Diddy was in the relationship. It was on Diddy's phone. He knows. He knew that they were loving and they texted each other that they loved each other. That's not new information. Just because you have the text messages to show that they had a toxic relationship does not then mean that he didn't traffic her and that he didn't abuse her. It just doesn't make any sense to me. I don't know what the argument is. I'm with the prosecution on that. It absolutely does not mean that. I don't know where they thought that was going. Okay. Furthermore, in presenting recently produced text messages, the defendants cherry picks to paint a misleading picture, ignoring numerous other messages in the record between the defendant and victim one, documenting the defendant's physical abuse of victim one and his threats to expose recordings of freak-offs. Text messages read, "You know what sick and disgusting..." Oh, I gotta get my bleeper. Okay. You know what's sick and disgusting? I was reminded of the other day, you forcing me to blank, or you were going to leak some freak off. I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. And I still have crazy bruising. I turn my head for a second and you get up and you drag me down the hall by my hair. I have bleeding cuts. You hit me in the head 2 good times. When you get up the wrong way, you always want to show me that you have the power and you knock me around. I'm not a rag doll. I'm someone's child. So these are supposed to be text messages coming from Cassie, of her basically saying you beat me all the time and that's not right. When you get mad or when you get effed up, I'm assuming under drugs or alcohol, you don't have an excuse to then beat me up, right? Or in his case, he's unfaithful and that gives him an excuse to beat her up. Moreover, despite attaching lengthy text messages between the defendant and victim one, on various dates between October and November 2018, the defendant omits messages produced in the same thread about defendant's violence. They don't tell us exactly what it says, but hopefully we will be, well, I guess there won't even be cameras in the trial. We'll have to go to the trial in person, y'all. The defendant also rehashes his attack on victim one's motives in bringing a civil lawsuit against the defendant, suggesting that victim one's allegations against the defendant were merely attempts to obtain a financial windfall from Mr. Combs. Across multiple bail hearings and in the instant brief, the defendant has made clear that his litigation strategy is to personally attack victim one, stooping to any depth to attempt to undermine her credibility. Setting aside this questionable strategy, none of the information that purportedly undermined victim one's motives was unknown to the defendant at the time of the initial bail hearing. Again, defense counsel made all of these arguments previously, and these arguments have no bearing on the question of bail. They really don't. You're just saying that you don't think that the evidence is strong enough. That's up to the jury to decide. The purpose of a bail motion is to determine whether there are conditions that will assure the safety of the community and the defendant's appearance in court, not to entertain the personal attacks on a statutory victim. To the extent that defendant takes issue with victim one's credibility, a trial is the appropriate forum to address that. Yes. So, and that's what I noted earlier. You're saying all of this stuff. This person sucks. That person sucks. The prosecution sucks. Let me out. How do we know that we're going to be safe, Diddy? Tell us how we're going to be safe. Tell us how you're not going to control this security staff this time. Tell us how you're going to wear an ankle monitor. Tell us how you've been a very good boy in jail so far. You can't tell us any of that. So instead, you stoop to the level of saying these victims are not victims. Basically, this case shouldn't even be against me because these people are not victims. Heck, me, Diddy, I'm the victim. That's what I get from this request for bond from Diddy, because he didn't talk about how the community will be safe. It was an opportunity to brag about himself and all the things he's done in the community and all the music he's made and how much money he makes, and he's involved with his liquor companies and all these different business ventures, which he's not participating in now because he's been kicked out of most of them and he's in jail. You have not said anything about how you're not going to tamper with witnesses. Nothing. You've said nothing about that. Because you can't. Because allegedly you've already been tampering with the witnesses so far. Okay. The state's next part, the court should reject the defendant's request to reopen the bail hearing because the defendant disagrees with the government's use of the term victim regarding to the second person. The defendant next accuses the government of misleading the court as to the nature of certain of the defendant's communications with another victim, victim 2. The government did no such thing. The defendant's primary point of contention appears to be that the government characterization of the individual as a victim. In quibbling about how to label victim 2, an individual to whom the defendant continues to pay a significant monthly sum, the defendant does not present any new evidence or any new information or grapple with the actual evidence. The messages and recordings between the defendant and victim 2 on which the government relied at the initial bail hearing are clear on the face that and consistent with the government's representation that the defendant was leveraging significant financial benefit to cause victim 2 to adopt his narrative of their relationship. Whether or not the defendant agrees with the characterization of victim 2 as a victim, for purposes of this criminal case, the communications highlighted by the government indicate that the defendant used financial coercion to attempt to feed victim 2 a narrative that was consistent with his defense theory, a theory at odds with the contemporaneous text messages sent by victim 2 to defendant and others. Just threaten and others. Blank, it says, the defendant just threatened me about sex tapes where I am heavily drugged, which that is a big contention here, and doing things he asked of me. Another message describing victim 2's sexual trauma. In light of the defendant's continuing financial support of victim 2, it is not the government, but rather the defendant who is misleading the court. And I can't remember if this was the witness or the other witness, but essentially, you heard there, apparently Diddy is paying this victim to basically tell the story that Diddy wants them to tell. I wonder who it is. I don't know who it is. Let me know if y'all know who it is. I have no idea. But basically saying he's coercing them financially to stick with his theory. And that is a victim under the law. Diddy is saying, no, it's not a victim. They agreed with me. And the state is the prosecution is basically saying they agreed with you because you're threatening them. That doesn't mean that they're not a victim. The defendant contacts with witnesses demonstrate the threat he poses to the integrity of the proceedings. I believe victim 2 was the one that he was paying, and that was on the notepad, but I think we'll get into that in just a little bit. Okay, witness 1. The defendant's attempt to spin his contact with witnesses, including the witness served on the grand jury subpoenas, as evidence rebutting the government's proof of obstruction, fell in their entirety. For example, defendant claims that the government misled the court and concealed the actual content of the communication between the defendant and a witness who was served with a grand jury subpoena in June 2024. As an initial matter, the nature and substance of defendant's communication with witness 1 was known to the defendant at the time of the initial hearing. Again, this is not new information. But more importantly, these contexts, including the fact that defendant evidently deleted the messages from his phone, confirm the government's proffer at the initial hearing and refute statements made by defense counsel. Specifically, phone records show that between the end of 2022 and January 2024, witness 1 occasionally contacted defendant by phone without any response from defendant. That changed in June 2024. Witness 1 was served with a grand jury subpoena on June 19, 2024. So since January, they wasn't talking. Even when they were talking, Diddy was not responding to him, right? Before the January 2024. All of a sudden, witness 1 was served with a grand jury subpoena to testify at his indictment hearing. And all of a sudden on June 19th, Diddy got a whole lot to say to this witness. Okay. And after contacting the government, was appointed counsel on June 25th, 2024. Beginning on June 26, 2024, only after witness 1 had been served with a grand jury subpoena and had counsel, the defendant initiated contact with witness 1. So he hadn't talked to this witness for 7 months. Okay. And then all of a sudden, they're a part of the grand jury, and now Diddy wants to chat, which the defendant attempted to obscure by initially calling witness 1's wife and later communicating with witness 1 over a VoIP service, including by text and a call lasting over 7 minutes. 7 minutes. The following day, phone records indicate that witness 1 spoke with counsel for the defendant. Even though witness 1 was represented by counsel, which is illegal, attorneys cannot speak to represented parties. He and the defendant continued to directly exchange text messages, and defense counsel also spoke directly with witness one again on July 8th, 2024. Following witness one's testimony in the grand jury on July 25th, 2024, the defendant called and texted the witness again. The defendant repeated contacts with witness one despite his apparent knowledge that witness one was represented by counsel and had received a grand jury subpoena, undermines defense counsel's previous denials of defendant's interference with the government's grand jury investigation, and shows that counsel cannot stop the defendant from contacting grand jury witnesses. This concern is amplified by evidence indicating that defendant appears to have deleted messages with witness one, although the phone records confirm that defendant using a particular phone number and witness one exchanged multiple text messages from June 2024 to August 2024. There were no such messages recovered from the defendant's cell phone associated with that phone number. So not only is he contacting the witnesses, he's then deleting the evidence. But we all know that they can still get it. Nothing's ever really deleted, right? Okay. And then they go on to tampering with witness number 2. And the prosecution is like, his attorneys cannot control him. One, the attorneys are going to be in New York, and Diddy's asking to be in Florida. And they couldn't even stop him from doing his stuff in the jail cell. We're going to get into that in just a little bit in a moment. But even before he was arrested, he was messing with witnesses. And even the defense counsel was talking to witnesses that were represented without the attorney there. And you cannot do that as an attorney. The defendant also claims that the defendant's contact in September 2024 with an individual represented by counsel who wanted to make a public statement were not in any way obstructive because the defendant and witness 2 were previously in frequent contact. However, the contact between defendant and witness 2, who were bandmates, stopped in March 2024. So again, he's stopping his communication with the person. And from the timeline and the context of the defendant's contacts with witness 2, it is clear that when the defendant reinitiated contact with witness 2 in September 2024, his purpose was to ensure that witness 2 was on his side and to pressure witness 2 to make public statements denying allegations of violence by the defendant. The defendant reached out to witness 2 on September 11, 2024, and sent her a copy of the lawsuit against the defendant in which witness 2's name was mentioned several times. I don't know who this is. Do y'all know? Let me know if y'all know who that is. I was thinking that it would have been his like his little right-hand lady, because her name was mentioned in the lawsuit, but they're saying they were bandmates, and I don't remember her being in. Oh, it was the one in Don Richards' lawsuit. What was her name? That was allegedly in an abusive relationship with her husband. Oh, what was her name? I forgot. They were all Diddy, the lady, and Don was in the same group, but I never paid attention to that group, so I have no clue who it is. But now I know which one they're talking about. They're talking about Don's lawsuit. Okay. I figured it out on live stream. Yay. Okay. The defendant then called witness 2 and they spoke for nearly 6 minutes. After reading the lawsuit, witness 2 called the defendant back at his request and they spoke for 4 more minutes. Evidently, the defendant and witness 2 discussed witness 2 drafting a statement as immediately after the call. The defendant told witness 2 in a text message they blocked out what he actually said. The defendant then asked for witness 2's attorney's name. From September 11, 2024 through September 15, 2024, the defendant and witness 2 exchanged multiple texts and multiple calls, at least 128 phone contacts in total. Throughout these phone contacts, the defendant repeatedly asked witness 2 when she planned to post her statement. I didn't see the statement. Oh my gosh. She posted it on Instagram on September 13 of 2024. Then, after the defendant was in custody, BOP investigators recovered the following notes from the defendant's cell phone during the pre-planned nationwide BOP facilities. Okay, no, this was the witness that he was paying, that they're trying to determine whether this note was attorney-client privilege. Remember, we talked about it yesterday. Attorney-client privilege is communication to your attorney about your case, or just to your attorney in general, right? You can say whatever you want to your attorney. But if he's writing notes, that's probably going to be more on the lines of work product, notes or diagrams or whatever prepared in anticipation of litigation. However, although we know that those protections are strong, attorney-client privilege is strong, work product privilege is strong. Those are strong protections when it comes to legal cases. What you cannot do is commit a crime. And you know what a crime is? Bribing people, paying people in order to support your defense. That can fall into a crime. You're not supposed to be tampering with witnesses. That is a crime. One serious crime that the prosecution and the court is very concerned about. And so when they talked about paying a witness yesterday, I thought they were talking about an expert witness. But no, they're talking about someone who potentially witnessed Diddy's aggressive behavior towards other women, towards Cassie potentially, and towards Don Richards, if I'm talking about the right lawsuit. You're paying them to change the narrative, to support your position, like what the prosecution is arguing. So I thought they were talking about which expert witness they were going to pay. The defense did a good job in throwing out that expert witness name. None of that is mentioned here, right? They talk about him paying off a witness, which is illegal, and I think it's going to be able to remain a contention. I don't think that's going to be something that's going to be blacked out because it is a crime. That's my opinion. I don't know how the judge is going to rule on it, but in my opinion, paying off a witness to make a statement on Instagram is a crime, and it's witness tampering. And the court can ask about it at trial. Okay. The strong inference to be drawn from the defendant's communication with witness 2 and his personal notes is that the defendant paid witness 2 after she posted her statement. Can't do that. From the timeline, the content and the context of the communication between the defendant and witness 2, the defendant's clear goal was for witness 2 to draft and post a statement. Even after the defendant knew that witness 2 had counsel, he continued to reach out to her directly, a fact that clearly concerned Judge Carter, and rightfully so, that the defendant had multiple phone contacts with witness 2, up to and including March 2024, changes nothing about the darning timeline and content of the calls in September 2024. These communications are another example of the defendant using manipulation, influence, and power to persuade witnesses to support him. Yeah, that's bad. Based on the foregoing, the defendant has not demonstrated that he is entitled to reopening the bail hearing, and the law cited by the defendant provides him no support otherwise. So there's no new information here. There is no new information here, and so he should not be released on bail, is what the prosecution is arguing here. The defendant cannot rely on this code section for his relief. Alternatively, the defendant moves for pretrial release under this section, claiming that the defendant cannot adequately prepare for his MDC his defense at MDC. The law does not support the defendant's release under the provision either, as the defendant has amply been afforded reasonable opportunity to private consultation with counsel. So I'm just going to summarize this point because it's kind of boring. Basically, what they say, Diddy is arguing that he cannot prepare for his case because he cannot meet with the counsel, but his attorney. But he's able to have phone calls with his attorney that are not monitored, and he's able to use the conference rooms in the jail that are not monitored. The prosecution goes on to say that Diddy has actually met with his attorney most days since his incarceration 2 months ago. And he's able to meet with them up to 7 days a week. So they're basically saying this argument is not strong. As far as the laptop that they're claiming that they never gave to him, the prosecution indicated that they are working on getting the information onto the laptop so that Diddy can go ahead and review the information on the laptop so that he can review the discovery that his attorney said that he doesn't have enough time to review. And the prosecution does a good job at saying that, let me see here. Let's go ahead and just go into this paragraph. Let's just do this whole paragraph here. They go on to say voluminous discovery alone is not a basis for release under either the Bail Reform Act or the Sixth Amendment. The defendant does not point to any case law suggesting that discovery of the kind produced in this case requires the defendant's release under the code section. Let me see. While it may take a long time, it's not enough to basically release him. They then go on to say, moreover, the aggressive trial schedule was specifically requested by defendant. If he needs more time to review discovery, he can request an adjournment of the trial date. So remember, Diddy is the one that said he wants his right to a speedy trial. This is why we are going to trial in May. However, He was only arrested in September. So essentially, he's trying to go to trial within 9 months, not realizing that his team, the defense, is the one that has to play catch up and get all of the information in order to be adequately prepared for trial. Now he's saying that, oh, I don't have enough time to talk to my attorneys. I don't have enough time to review all of the evidence. Like I said earlier, dude, you knew you had all of them recordings in your house. You knew how much stuff that they took from your house. You knew that there was going to be a lot of evidence. So for you now to turn around and say, oh, I want my right to a speedy trial, but also I don't have enough time to review all the evidence, you can ask for a later trial date. I think that the government did a good job in pointing that out. They go on to say, finally, the defendant complaints about the conditions in MDC has come as a surprise to the government, given the contrary public statements made by defense counsel and the statements made by the defendant on the monitor call. Basically, Diddy says that, or the counsel for Diddy says that the worst part of jail is for Diddy is probably the food. And that, I think that was all I wanted to touch on that. And then also saying that the laptop was not prepared. They said that the defense never even brought this issue to their attention. They're working on it. They're almost done with it. And if the defense counsel thought they should be working on it a little bit faster, the defense counsel could have said something, and then they would have worked on whatever their issues were with them. Next part that the prosecution says a reason why he should not be released on bail is that the defendant poses a serious risk of obstruction, danger in flight. For the reasons discussed above, the defendant has not met his burden and demonstrated that he is entitled to even a bail hearing under what he's arguing. In addition to not being entitled to a bail hearing because there's no new evidence, right? He also shouldn't be able to be released on bail. He's not entitled to a bail hearing because the conditions of being in jail does not entitle him to release. The conditions of being in jail does not automatically qualify him to be released. Another thing that they pointed into for the conditions in the MDC is that just because he's rich, he shouldn't be able to buy he shouldn't be able to buy his way out of jail, which to me seems like what Diddy is trying to do. He's like, oh, I'll hire private security. I'll handle this. I'll handle that. No worry, court. You don't have anything to worry about. And the prosecution is like, no, he shouldn't be able to buy his way out of jail. And we have to leave poor people in jail because they cannot afford to hire private security. Not only has he not proven that the conditions are a reason for him to be let out of jail and that he has no new evidence for a reason to be entitled to a new bail hearing, they're also saying that he shouldn't be entitled to bail in general because he obstructs people. He messes with a witness. He messes with victims. And he has been doing it in jail. So let's see what Diddy has been doing in jail for the state to believe that Diddy should not be released on bail. As noted above, the evidence presented to Judge T and Judge Carter amplifies support their, As noted above, the evidence presented to Judge T and Judge Carter supported their feelings. No, that was just written bad. Okay. Supported their findings that the defendant posed a risk to obstruction justifying pretrial detention and would be sufficient for the court to find the same. However, to the extent there was any doubt about the defendant's risk of obstruction at the time of the prior bail hearings, no such doubt is now non-existent. Since the defendant has been detained in MDC, he has continued to try to evade the law. Enforcement monitoring, corruptly influence witness testimony, and further attack the integrity of the proceedings. Specifically, while in custody at MDC, the defendant has repeatedly communicated with others in ways that violate BOP rules and are designed to evade BOP and law enforcement monitoring, including as described below, using PAC numbers that belong to other inmates to make calls, using three-way calls to contact other individuals, including individuals who are not on his approved contact list, and using an unauthorized third-party communication system to send messages to numerous individuals, including unauthorized contacts. Other inmates' PAC numbers, basically each inmate has a code that they have to use in order to dial out. And Diddy has basically consulted with 8 inmates and has used their PAC in order to call people that are not on his approved list, or some people that are on his approved list, and he's basically paying them allegedly paying them by sending them money electronically or sending their family money electronically or putting money on their books, which is illegal. We're not going to go all the way into it. And then in addition to that, he is frequently instructing people who he is on the phone with through his own number to three-way call other family members that are either on his approved contact list or not on his approved contact list. He's not allowed to do three-way calls. The jail has to be able to monitor who he's communicating with and to ensure that he's not obstructing justice, right? You can't then go and pull other people and tell that person to go tell JJ and all of them to do this and yell at this witness. You cannot do that. And then he's using a non-authorized messaging service. They have some type of email service set up to where they can text message their family. But apparently Diddy is sending messages to an email that's registered under his son's name, but it's not actually going to his son. They also go on to say that he basically constructed this whole media circus around his birthday and caused his entire family to gather together and post and talk about how they miss him in order to basically kind of sway the jury and say, oh my gosh, he's such a loved person, and to put out this positive message about Diddy and how much his family loves him and they miss him and they want to be in his presence. The defendant is a danger to others. In addition to failing to meaningfully contend with the ongoing risk of obstruction the defendant poses, he also spends no time addressing the significant acts of physical violence that the government highlighted at the initial hearing, which led Judge Carter to conclude that the defendant is a danger to the safety of others and the community more generally. Indeed, as the record before the court makes clear that defendant's long history of violence demonstrates dangerousness. Moreover, contrary to the defendant's claim that the evidence is thin, evidence supporting the defendant's long history of abuse, including witness testimony, communications, photos, and videos, police reports, and other materials demonstrate the strength of the government's case against defendant, a factor considered by the court under the statute. I forgot what they were talking about here. Oh, they were talking about the toxic relationship between Cassie and the fact that he was willing to beat her makes it more likely for him to be willing to be violent to other people, such as witnesses, and the fact that he did it on video, right? They continue to say that he is a flight risk. The defendant has not rebutted the presumption that there is no condition to assure his future presence at the hearing. Like I said, he is asking to be in Miami for one, on his house that's on the water, that has yachts all next to it. His neighbors got yachts, he got yachts, and he also still has his plane while his attorneys are working on selling it. And he's saying, oh, well, he gave up his passport, so, that's going to make it so that he can't travel. Like, come on now. He's a celebrity. If he wanted to get away, he definitely could get away. He said, in this case, the defendant has incentive to flee given the potential punishment and the nature of the evidence that will be presented at trial, and has nearly limitless resources to facilitate his flight. While counsel took steps to mitigate the defendant's substantial risk of flight before the indictment, the defendant's incentives have changed materially now that he faces the very real possibility of a substantial term of incarceration. So, like we said earlier, the minimum that he is facing is 15 years. The maximum that he is facing is life in prison. So although he didn't flee before he was arrested, now he knows that he's facing life in prison. So he is probably a little bit more likely to flee than he was previously. As we can tell, he thinks he's going to get off. He thinks he's going to get bail. He thinks he doesn't have to comply with the rules. He's breaking all the rules in jail. What makes us think he's not going to run away? If he's breaking rules in jail with all the security that they have, all the monitoring that they have, if he's breaking rules in there, paying off witnesses, what makes us think he's not going to do it outside when he's in his house, on the water, with his plane and his boat? Why would we think that he's not going to go anywhere? And he's going to have this private security team that somehow he's not going to have any control over, and he's not going to be able to coerce them. Okay. So they go on to say is that the proposed bail package is not sufficient. Diddy is able to do all of this stuff in jail. He has been able to taint his family members. He has done three-way calls with his family members, directed them to do something, and then his family members are doing them. And he wants us to believe that he's not going to flee because he's not going to leave his kids behind. Who's to say that Diddy's not going to take his kids with him if he really wanted to flee, right? The defendant's emphasis on the 24/7 security, let me see, is also problematic. The defendant has demonstrated an uncanny ability to get others to do his bidding, employees, family members, and MDC inmates alike. There's no reason to believe that private security personnel would be immune. Let's see here. Let me see. And this is where they go into Diddy should not be able to basically create his own jail, right? At any rate, the defendant's private jail proposal, which is what he's suggesting, I'm going to hire private security that's going to monitor me. Do we believe this, Diddy? No, we do not. At any rate, the defendant's private jail proposal at best elaborately replicates a detention facility without the confidence in the security of such facilities. Moreover, the Second Circuit has expressly decried attempts like the defendant to pay his way out of detention. If poor people can't get out and hire private security, rich people shouldn't be able to do it. And they also note that when it is common, it is very rare for the court to release defendants based on what the prosecution wrote. I'm not a criminal attorney, so I'm just going off of what the prosecution wrote. When they do allow this kind of private security, it's for people that either have like a terminal illness or that are severely injured. Diddy is none of these things, okay? He is none of these things. So essentially the prosecution is saying that he shouldn't even be afforded the opportunity for that option because he doesn't have any serious concerns as to why he needs to be out of the jail on bail and monitored by private security. Okay. The defendant's updated proposal simply does not alleviate the risk of danger, obstruction, and flight, particularly in light of the defendant's inability to comply with the BOP regulations and his efforts to engage in this obstructive conduct, even while subject to monitoring at the MDC. Basically, Diddy should stay in jail. And with that, I do agree with the prosecution that he is going to be a risk. If they let him out, we ain't gonna see Diddy. Diddy is gonna disappear. If they let Diddy out, Diddy is gonna disappear. We're not gonna see him. We're gonna have missed hearings. That's my opinion, y'all. Missed hearings. He's not gonna do what the court is going to need him to do. And I don't think that the private security is gonna be appropriate for him. I think he needs to stay in jail. Y'all let me know. Do y'all think that Diddy needs to stay in jail, or should we give him the opportunity to be released? He's using other people's phone numbers. He's doing 3-way calls when he's not supposed to. He's texting people that he's claiming is his son and it's not his son. He's organizing Instagram campaigns, allegedly. He's paying off witnesses to say what he wants them to say. Do we really think that Diddy should not be locked up? I don't think so. I think he needs to be locked up. I think he needs to be locked up, and that is all. That's my only opinion. Let's see what the chat has to say. If y'all have comments about the case, go ahead and let me know your thoughts in the chat if you're watching on live. And again, y'all, I'm looking at the likes. We're at 40 likes with 123 people watching live. Please hit the like button, y'all. Support the stream. Support the stream. It's free. It helps me. If you're new here and you're not subscribed, please subscribe. It helps me. We cover cases like this. We're going to be covering the Diddy case, and other cases alike. We got some copyright lawsuits coming up, some other kind of lawsuits coming up. Y'all, we're at 40 likes. Hit the like button. Help us sister out. Help the algorithm out. 123 people and only 40 likes. All right. Anyways, let's go ahead and jump into the chat to see what the chat has to say about the case. We got Chelsea B saying, I have a feeling there's a lot of T. Diddy we haven't even heard yet. Yeah, I think the prosecution gave us a good insight into what's going on. And I think it honestly gets worse. I think it gets worse. And hopefully we'll learn about it a little bit more. We got Dr. Fish saying, I believe they will let him out on bail. Oh, really? Why do we think that he's going to be let out on bail? I don't think so. I know people were saying with the prosecution potentially messing up with the attorney-client privilege stuff that they're going to let him out. I don't think they're going to let him out. I really don't. That to me, they have so much more evidence beyond that I don't think they're going to let him out. Let me know what y'all think. Sardonism says, would never have guessed that the attorneys in the case would be so shady. Little shady. And the court called him out. Writing legal on the documents and the pictures don't show legal on the documents? Yeah. I think the defense is just as shady as their client. Cheryl Reed says, why do some things so obvious, especially if you're trying to get bail? I think he thought that the judge wasn't going to notice. And the crazy part is they filed that motion and the judge didn't review it before the hearing. And then after the hearing, they reviewed it. They're like, yeah, he made an argument about look at this notepad. The notepad says illegal, but this picture doesn't say legal. Where did he get that from? I think they put it on there. Denny said, there's no way they're letting him out. I'm with you on that. I don't think he's going to get out. It's just too much. He's already been violating the rules. Connie Sharebear Cat says, evening, hit like and subscribe, watchers, and agreed. They are not letting him out at this point. I don't think so. It's too much. And I think there's going to be so many more claims coming against him that they're going to have to keep him in there. Y'all, we made the like goal 75. We're at 47. We got 7 people that hit the like button. I know there's people in here that hasn't hit the like button. Okay. Let's make we made the like goal 75 likes. We're 25 away and there's 110 people in here. So I know people have not hit the like button. Help a sister out. Come on, help me out. Cheryl Reed says arrogance kept him from fleeing after the initial raid. Hubris will keep him in Miami because in his mind, he believes he's going to get out of this mess. Do you think so? I think if he goes to Miami, he's gone. That's my opinion, Cheryl. I don't know. I think if he gets out to Miami, he's gone. We are not going to see Diddy. He might stay for a couple months. He might stay for a couple of months. He might even go to the trial. But I think he's going to be gone after that. Jazzy G says, hey, everyone. Hello, welcome in. Jazzy G says he should not be let out. I agree. He is going to be tampering with witnesses left and right. Left and right. Chelsea B says he's a flight risk and a master manipulator. Keep him in there. I'll have to agree with that. Kristen at first says, no, I got my notification late. Hello, Bree. Hello, BriHive. It's been a while, but glad to be able to finally join a live again. Hope you all have been well. Welcome back. Nice to have you in the live stream. I'm trying to live stream a little bit more often because there's so much to talk about. And if I try to do pre-records, I'm never going to get the content out to y'all. I just can't with work and, research and everything. So welcome back, Kristen Affair. We have not seen you in a long time. Sardonism says, how the F are they finding any comparable cases in neighboring districts, in my opinion? There was actually the CEO of Abercrombie and Finch. That's who they're talking about, that case. He was accused of sex trafficking men. And apparently also did witness intimidation by having a private security company who Diddy is trying to have monitor him. They put that in their own freaking documents. They're having a private security company basically intimidate the witnesses. So yes, there are other cases like this. And also think about Epstein. I believe that one was brought in New York as well. So I mean, New York seems to be a popular destination for trafficking people. Jazzy G says redactions. Yeah, we don't like redactions. We want to know what's the tea. Jazzy G says we all seen the hotel video though. Right. It was a loving relationship though. He just cheated sometimes. Sir, what does cheating have to do with beating people up? Please let me know. Please let me know, okay? Cheryl Reed cracking up. Jab says, F no P. Diddy loves the taste of what? The smell. Okay, we're not reading that on the live stream. Y'all saw it in the chat. Eloy said, hit the like button. BriHive, thank you for the reminder. Yes, y'all, if y'all haven't hit the like button, we're at 53. So 5 more people or 6 more people hit it. Like goal for 75. We can do it. We can literally do it, y'all. We are 22 likes away. And there's at least 40 people in here that has not hit the like button. You should feel guilty. You should really feel guilty. Tiffany Davis says, honestly, all these people coming forward every week with sickening allegations, some caught lying, the lawyers getting sued, the fake Kim books, and etc. has made me believe Diddy is being targeted. Do you believe that he's being targeted? I don't think he's being targeted. I believe it. I believe that Diddy is a creep 100%. Are there going to be lawsuits that they're going to have to flesh through? I think there will be, but there's so many more lawsuits prior to the Tony Busby's lawsuits. Those are the ones that I think are more going to need to be flushed through. But the other ones, how quickly he settled Cassie, I think the Rodney Jones one is going to uphold. I think Don Richards is going to uphold. I think there's going to be a lot of cases. Excuse me, I got the hiccups. A lot of cases that are going to uphold that he's not going to be able to get out of. So I definitely see that everyone's coming out. I think people are seeing this as an opportunity. The statute of limitations has been extended. So I definitely understand why people are coming out now. I don't think he's being targeted. Maybe he is being targeted because he's messed up. But also, I think there's going to be a lot of evidence against him. 23.5 terabytes. Like I said, I don't know how big a terabyte is, but it sounds big. It sounds big because I never use the word terabyte. I don't have terabytes on my computer. So there's going to be evidence there. Primo 1973 says, nah, he ain't going nowhere. I'm not even going to entertain it. I'm with you there. Jab says, Diddy goes to prison forever. Haha. Yep, for life. He's facing life and he's already in his 50s. So yeah, his forever. He'll be there. Tiffany Davis says, I only believe Cassie in her experience because of the hotel video and there should be justice for her. I agree with that. But I think when people are susceptible to doing that to someone that they've been in a relationship for 10 years, I think that, I don't know. I believe it. But you could probably come out and allege anything negative against any celebrity, and I would probably believe it. So maybe I'm not the best one to be taking the belief from. Jab says, what defense do little boys... Oh, yeah, we're not reading that. All caps. Chelsea V says, so would you not believe Cassie if the video didn't exist? There are many people who have called out Diddy not as victims. That is true. I would, the lawsuit against Tony Busby, I have not been able to find it. Once that document becomes available, we're going to look at it. We're going to see what the allegations is. I would really like to know who the celebrity is that's suing him. But also, do we think that that celebrity is trying to distract from everyone else that actually has valid claims? I do think that they're going to have to sort out through some of the later lawsuits, especially the ones filed by Tony Busby, because he has allegedly done this to someone else where he kind of, advertised for victims. Like, you ever see those commercials where they're like, have you been exposed to this, blah, blah, blah? I'm imagining that he did some type of advertisement like that, but I've never seen that done for SA victims. That to me is crazy. Like join our class action kind of mess. It kind of seems like what he did, which is a little bit scammy as a lawyer to me, but I don't think that means that the stories are not real. But I think were you referring to me or were you referring to the person, Tiffany in the chat? Because I believe them. I believe that he did all the things, okay? All of them. Jazzy G says they're grasping at straws to try to defend him and to try to get him out. He just wants to tell his story. And the way that he's writing his request to be released on bail, I think the prosecution was absolutely right. You didn't address how he's not going to be a danger. You just saying, no, I didn't intimidate witnesses because it shows that I had nice conversations with people. I wasn't persuading them. I wasn't manipulating them. I just paid them off. That's intimidation. That's financial coercion. I think the way that he is telling his position, like even the whole part of him bragging about himself, it comes off as, I'm not diagnosing anyone, and I know people use this word loosely, but it comes off as very narcissistic, grandiose. It's all about him. Cassie only wanted money from me, but I paid her so that she didn't release the book because you knew it was going to be in that book, sir. You knew what you was doing. And because she was scared to leave you, you think that means she's not a victim? Come on, dude. You can't be that full of yourself. Hi, Just Stacy. Welcome in. Shoreen says to agree with Tiffany Davis. Shoreen says he should have run for president. No consequences, no jail time. Are you talking about our new president or our returning president? Yeah, well, if he gets off, he'll be able to run for president, right? AT1 CVB41, which is odd. How can you be a felon in the president, but if you're a felon and you can't vote, if you're a felon, you can't vote. So Trump couldn't even vote if he wasn't running for president, but he can be president? That's stupid. is really stupid. I just thought about that. 181 says to me, terabyte equals 100,000 gigabytes, decimal or 124 gigabytes if binary. It depends on how it is counted, i.e. decimal versus binary. Oh, thank you. I still don't know what that means. I think my computer has like 256 gigabytes. So I don't even meet the qualification for a terabyte. My computer cannot support a terabyte. And he had 23.5 terabytes. And he thought he was going to be able to go to trial in 9 months. I don't think so. He's going to have to push it back like everyone else is pushing their trials back. Chelsea B says, I just want 50 Cent documentary. What's going to be all the tea that Hollywood's spilling? Do you think, you're thinking that 50 Cent did something bad or that he's going to tell everybody business? I haven't really heard anything bad about 50 Cent. Connie Sharebear Cat says, they are throwing the same old spaghetti at the wall and nothing is sticking. It's literally the same allegations. It's, oh, we got discovery and we think the prosecution is wrong at the way that they're reading the evidence. That's going to be up to the trier of fact. Not you, Diddy. Not you. You already don't think the girl was a victim. Like, why are we listening to you? Nadine Philly says he is out of touch, hasn't been living in the real world in a very long time. And I think the other thing about it is that he's been getting away with it for so long. He probably really feels like he's not going to be touched in this. He's going to be able to get away with it. He's gotten away allegedly with other criminal conduct. So he thinks this is just another run of the mill, right? This is nothing new. Something very, not demure. Very demure. He's gonna get through it, right? Jazzy G says agree with Nadine. Nurse, not lawyer, said Diddy got a diddle. He's gonna try to diddle if he gets out into his house. Like, come on, he's being accused of messing with minors. They better not let him out of this house. I'm sorry, let him out of the jail. Cheryl Reed says, so with everything prosecution has put forward, how does denying bail not violate Diddy's rights? Because regardless of how people feel about him, he is entitled to a fair trial. He will get a fair trial. That doesn't mean that he should be out on bail. There's people that don't even get an opportunity for bail. It's up to Diddy to prove why he should not be in jail. It's the burden of proof is on him. He did not meet the burden of proof. He just said, I'm cool. You're not, let me out. I'm not going to run. I promise I'm not going to run. Fingers crossed, right? He didn't do anything to overcome the burden, right? Jesse G reminded everyone to like the video. Of course, thank you for the reminder. We're at 57, y'all. We are 18 away. I'm doing math on the fly, y'all. I'm doing math on the fly. We are 18 away from the 75 like goal. So if you haven't hit the like button, please do. Thank you for the reminder, Jazzy G. Chelsea B says to Cheryl Reed, he's a flight risk to never make trial. I agree. I think he'll show up to a couple of hearings and so people can say, oh, see, he's not running, and then he'll run. He'll run right before the trial, in my opinion. But also, in my opinion, I don't think he's getting out. For Latavia, it says Cocoa Puff's gonna be 80 before he sees the sunshine. You call him Cocoa Puffs? I've never heard him referred to as that. Cheryl Reed says to Chelsea B, well, there's that. Yeah, he's gonna run. He's gonna run. Jazzy G says, do we know there won't be cameras or live audio for the trial? I actually don't know that. They haven't had it in the hearings, so I would assume that they're not going to have it in trial either. Chelsea B says to Cheryl Reed, I'm thinking his self-hired security to keep him here and in check won't be effective, LOL. I don't think so. I don't think anything will be effective. I think if this is just my opinion, if he had to choose between him going to jail or letting all his kids burn in the house fire, in my opinion, I think he would let them kids burn in the house fire. I think he would choose, and that's just an analogy for, I think he would choose self any and every time. That man is not going to jail. He will not be R. Kelly, okay? He will not sit in jail. He will not accept his responsibilities. If they let him out, he's going to go. I think R. Kelly was held in jail the entire time, if I'm not mistaken. I didn't follow R. Kelly's case very closely, but y'all let me know. Was R. Kelly held in prison? R. Kelly. I believe he was held in prison the entire time. And then for his next case, they just transferred him over to the next state. Let me see. Was he released on bail before I'm talking? Oh, no. They did release him on bail in February of 2019. But also R. Kelly was broke. By the time R. Kelly went to jail, he was broke because he was too busy paying off everybody that he's already abused. So actually, I was wrong. They did release R. Kelly. Are they going to release Diddy? I don't think so. Chelsea B says to Jazzy G, New York doesn't allow televised trials. Okay, so we won't have TV. Jazzy G says, okay. Chelsea B says, which is too bad because I would like to watch this one. Agreed. I would have to go in person. Jazzy G says, yes, would love to watch the trial. Jazzy G says, dirty money. And if he's going to jail, how is he able to even still use his money from, I guess because they're probably not going to be able to tie it to the freak off. So maybe that's why he can still use his money. But I'm pretty sure forfeiture is in this case, if I'm not mistaken. Jesse G says, Google says Kalina Harper, the other Dirty Money member. Okay, that's what you were talking about, Dirty Money. That was the group of the bandmate who they're referring to. That Dawn Richard did the, I think her last name is Richard. Yeah, that she did the lawsuit and named her in the case. And Diddy was like, look, they're naming you. You want to be on the right side of this or the wrong side of this, right? Chelsea B says defense is really in here arguing that he's never been held accountable before, so he would like to continue that. Exactly. No. Why are we holding him in jail? Y'all let everybody else go outside. Let him go outside. Last time Diddy was outside, a lot of people got hurt. So Diddy needs to stay inside. Everyone's been safer with him in there. Tavia says, if I was Judge Dude would stay in jail. Yeah, Dude needs to stay in jail for sure. Cheryl Reed says, yeah, rich people do it all the time, pay their way out of jail. Yup. Nadine Philly says, he can't even behave in jail, so why would he behave at home? LOL. With some random security company with no ankle monitor in Miami, mind you. He wants to go to Miami. The case is in New York. Okay? And I tell you, I was literally there last weekend. His house is on the water. All the neighbors got a yacht. All he do is got to walk next door and get on his neighbor's yacht, and he's gone. Diddy's gone. He don't even got to take his own yacht. Okay, Kristen the First says 100% agree that he should stay in jail. Agreed. June B says Diddy is going to skedaddle the first chance he gets. I think he'll stay a little while. But not for long. Four Seasons says jail for life. Needs to. Star Z Light says stay in jail. Diddy is doing the most. And he just wants to tell his story. He wants to tell his story multiple times. He'll give up eventually. Jazzy G says, I think it's even easier for his lawyers if he stays in. They can't control. They won't be able to find him. They're like, Diddy's only going to have one phone that's going to be monitored. Your Honor, he had a code that he was only supposed to use, and he managed in 2 months to convince 8 inmates to allow him to use their code. And y'all want me to believe this man had 23 terabytes, 23.5 terabytes, which AT1 just let us know that's 1,000 gigabytes. Okay. So he had what? 20 million, 2 million, however many. I'm not doing that kind of math on the stream. But he had all these terabytes of videos, and y'all want me to believe he gonna have one phone that's monitored? One phone? He for sure gonna have like 10 phones. He emailing people saying he emailing his son, and he really emailing everybody else. He doing 3-way calls in jail. And the prosecution has evidence of this. And y'all think he not gonna be 3-1 calling in his mansion? I think he got like a secret escape route in there. Like an underground railroad or something going on in there. I think he can go underground and get out of his house that way. I would not be surprised. Why do you keep wanting to go back to that house? The case is in New York. You ain't got a place in New York? I feel like he does. Kristen at first says, considering the amount of wealth and connection he has outside of jail, it's too big of a risk, in my opinion. I agree. Chelsea B says, I also think it would be a complete slap in the face to all the victims who are telling their stories to just let him out because of money, knowing they may never see a trial. Yeah, that is the other big thing I didn't think about. All these people have now come out and told their stories. If he's out of jail, he's getting to them. He's getting the people in jail. He's like a mob boss. Come on now. Chanel 3 says, I think he should be let out to fight his case. Really? He can fight it from behind bars, in my opinion. Sarah Boone wasn't let out. Just Stacy says, definitely a big risk to let him out. I agree. Isaac Abraham says, I think Diddy and his lawyer came up with a document plan on someone else's phone line. Which document plan? Oh, like the to write legal on the documents that was presented. And basically to write like legal on everything to try to claim. So basically, when you do attorney-client privilege or work product, you just writing this is attorney-client work product or this is attorney work product does not make it attorney work product. And also, if I remember correctly from law school, because I don't really have to do this, it's what the attorney prepares, or you're preparing it at the direction of attorney at the direction of your attorney as the client. I don't think you can just write notes and says this is work product. Or maybe you can if you're unrepresented. I think you can. I don't know. I'll have to look into that a little bit more. But just because you write work product on it at the top of the paper, on the side of the paper, or anything, a lawyer should have learned this in law school. It does not mean that the entire thing is work product. They can go through and redact it, which is what the prosecution did. Okay, this is work product. This is not work product. This is illegal, so it's definitely not work product. You can't commit crimes. You can't write down the crimes you're committing. And Diddy, why are you writing down your crimes? Okay? Why are you doing that? Thought you were smarter than that. But yeah, just because they write legal or work product on a document does not mean the entire page, does not mean the entire notebook, none of that. That's not how that works. And I'm surprised the prosecution didn't call that out. They didn't note that they had a filter team take out what would be attorney-client or work product, but they didn't really go into those rules that anything that says work product or anything that says attorney-client privilege does not necessarily mean that it's attorney-client privilege or work product. So Chanel Street says to Tiffany Davis, I do too. I forgot what Tiffany Davis said. Hunter DP says, is this live? This is live. It is live. I am live. Isaac Abraham says, it's fishy how this document thing came days before the third bail hearing. Yeah. They took it as an opportunity to try to throw another wrench, and I think it backfired on them. Jazzy G says, yes, it's live. Yes, I am live. Always live. Hunter DP says, I've never been any channel live. You never been on any channel live? Well, welcome. Channel Street says, Abercrombie guy is out and fighting his case. Yes, he is. But one other thing to note by the Abercrombie guy's case is that the prosecution actually asked for him to be released on bail because they didn't think that he was a danger and a flight risk. Now, it could be other factors playing in there, right? But the prosecutors on this case believes that Diddy is a flight risk and that he is a danger and that he's already tampered with witnesses and he's doing it from behind the jail cell, apparently. So the prosecution is not on the side of releasing him. So it's going to be up to Diddy to overcome the burden to say that he's not a danger and he's not a flight risk. And he didn't do it. He just didn't do it. He just said, I'm a good guy. The prosecution is a liar. The more and more I talk about him, he sounds like Kamala is at a dance party with Beyonce. Oh, the prosecution's a liar. You guys should let me out. Mm-hmm. The prosecution doesn't have a strong case. Let me out. Mm-hmm. But the prosecution said you can't get out of jail, so overcome the burden. Oh, you can't. You're going to stay in there. Okay. Chanel 3 says they released him on a $10 million bond. Yes, we did just go over that. They did release Abercrombie guy on a $10 million bond, and Diddy actually referenced that in his request for his own bond. He saw that and he's like, this guy gets out. What about me? What about me? He also threatened witnesses with his private security company, but I want my private security company to watch me and make sure I don't do bad things. No. Diddy didn't even offer the ankle monitor, the GPS monitoring. All he said is he's going to have a private security. Diddy is going to be on somebody's yacht if he gets out. And we're never going to see him again. We'll never see him again. He'll be living in Mexico, Guatemala, or somewhere, living his best life. Cheryl Reed says, I blocked that person. Which person? Hunter DP says, where's the like button? It is under the live stream, under my face. It's a little thumbs up button. Isaac Abraham says, were children involved in that case, in the Abercrombie case? I don't think so. I think it was like young men, probably barely legal, but I don't think it involved children. But technically, Diddy's case does not involve children. It's only about Cassie, although she was barely legal when it started. This particular case does not involve children. June B says the like button is under the channel name. Thank you. Hunter found it. Hunter DP says, I press the like button. Hope it makes a difference. Thank you very much. We're now at 61 likes. So shout out to the BriHive for hitting the like button and Hunter DP for making sure to hit the like button. Cheryl Reed says class action suits. He was like literally Tony Busby was making it seem like this is a class action. Channel Street says Vince McCohen sex trafficking charges. None of these men are incarcerated. Yeah. And again, it also depends on your prosecutor. I'm not familiar with that case. Unless that's the Abercrombie guy. I thought that was Jeffries, but I could be wrong. Chelsea B says that comment was directed towards the previous comment of only believing her because there was a video, not you. Okay. Okay. I was like, wait, did I say I didn't believe her? No. Stacey Watson says the Busby case was just submitted to the LA Superior Court today, so it should be available within 48 hours. So by at least Friday. Oh, they said that it was filed on Monday. So I was looking for it for yesterday. I spent like $6 trying to pull that case yesterday. I was typing in the names different and all kinds of stuff. I wasted like $6 trying to pull the case. So once it's available, we will talk about it. Hunter DP, thank you, Stacey. Hunter DP says, as for P. Diddy, he was always weird ever since the two rappers died, and his name was always in the mix. And after Biggie's death, he did a concert for cash grab. Just saying, never seemed honest. He doesn't seem honest to me. He seems weird to me. Seems like he never was cool in high school or something. That's bad. Disregard that, y'all. Isaac Abraham says, because the felonies are false. As far as, I don't know what you're referring to there. John Chow says, I'm homeless, living in my car with only $1,200 left. I'm sorry to hear that. Chelsea B says, not false according to the court. Yeah, and the prosecution still has to prove it, right? They have to prove it, but he can't just go, oh, well, their case is not strong enough against me, so I get to walk. Like, it doesn't work like that. You can't do that. Hunter DP says, P. Diddy vibe was always creepy. I have to agree with that. Chelsea B says, no, 50 Cent is making a documentary about Diddy, as he should. As he should. Him says, your hair looks great. Thank you very much, my fluff puff. Thank you. Hunter DP says, yay. Hunter DP says, P. Diddy seems selfish. Oh, he's like, the way he's describing his case feels really narcissistic to me. Hunter DP says, didn't the prosecutor say he was using his kids to take the jury pool and make him seem more likable? Yes. And that was, he's basically allegedly directing his kids to do certain things, such as like posting on his Instagram. One of his kids said they're taking over his Instagram to basically keep Diddy's, name alive. Do we need it alive? It is alive. But they did like a birthday gathering to show how much they missed him and how much he's a family guy and he supports his kids and stuff like that. So yes, they are claiming that he's putting things out there to make him seem more likable and actually to tank the jury pool. Like he's literally using the language, although the prosecution hasn't released the language yet, but they're saying it as though he's literally using the language like, we need to tank the jury pool. Like just direct like that. And then he's writing legal on top. Legal. Don't touch my attorney-client privilege document. You can't commit crimes and claim attorney-client privilege. Hunter DP says, didn't get caught putting money on other people's prison card and made three-way calls, and that's not allowed. And he's using a cell phone. The reason he isn't allowed out because they accused him. Yes, exactly. He is accused of doing three-way calls when he's not supposed to on his own phone line and on other people's phone lines. He's using other people's phone lines, and he's using a messaging app. I don't know if it's a cell phone. It was a messaging app that was registered to be messaging his son, but he's really messaging someone else. Stacey Watson says he was going to pull a Roman Polanski if he gets out. He's gone. He's gone with the win if he gets out. Hunter DP says, yes, Stacey is why they won't let him out. Yep. Hunter DP says he's doing all sorts of illegal crap, even locked up. Exactly. They can't control him in jail with the security. Y'all think you think you're gonna be able to control him in his own house that we don't even know if it has like an underground cave or something? Cheryl Reed says that's because Sarah Boone didn't have any money. Exactly. So why should Diddy be able to buy his way out? Why? And then put the house that he's gonna be living in up for bond. You know why? He's going to go and spend his last couple weeks there, and then he's going to disappear, and y'all can have the house because he's not coming back. He is not coming back. Kristen first says to Hunter DP, exactly. How can his lawyers claim he'll behave at home when he's already making schemes in jail? Makes no sense. Exactly. I don't think the lawyers know. I feel like they don't be knowing what's going on. Cheryl Reed says, of course there are other factors for an Abercrombie guy. Yes. And I'm not super familiar with his case. So maybe I'll look into it and see what he's being accused of. But I do know in his case, the prosecution was in favor of him being released. This prosecution is not in favor of him being released because of the extent of his witness tampering and the likelihood that they're going to bring more charges against him. So what are they going to release him on bail? And then when they bring the superseding charges, bring him back to jail? Like it really doesn't make any sense. Clyde Jones says innocent until proven guilty. That is true, but I think he's guilty. Luckily, I'm not on the jury, right? Lady Law Sandra says, new here, love your POV. Thank you very much. Welcome to the BriHive. Stacey Watson says the plaintiff will also be a John Doe, if that helps. Yes, I searched John Doe and about 400 cases popped up in the last month. And I didn't go through each and every one of them, but I tried to see which ones had like a relevant case topic and tried to find it that way. But I am going to wait until it actually pops up. I'll probably look it up on Friday. Thank you for that update. Jazzy G says, I feel like his kids, the adult ones, should lay low and stay out of it. Yes, because one of his kids is being accused of SA2 in a civil lawsuit. Chelsea B says, I think not cool in high school is an accurate read here. I don't know. It just came to me. My guy peaked. Or maybe he peaked in high school. I don't know. Definitely comes off as narcissistic to me. Definitely comes off as he gets what he wants. So he's going to continue to do what he wants. I'm definitely seeing that we're at 65 likes with 89 people watching live. So if you haven't hit the like button, our like goal for the live stream was 75. I would definitely appreciate it if we could reach the like goal for the live stream. Moving on. Thank you, chat. Everybody participating in the chat and giving me your thoughts about the case and whether Diddy should be locked up and all of the things. I am going to try to find the lawsuit against Tony Busby, which I am being told would probably come out within the next couple of days. I spent my $6. Hopefully I got some more dollar charges that I can use for the rest of the month. And we'll be able to find it and go through those documents there. And like I said earlier in the stream, we have some other cases, some copyright cases that we're going to be looking into. I should be back tomorrow live streaming. Hopefully the defense's response to the state's response today will be done. I'm happy they didn't turn it in today because this was a longer live stream than I expected, honestly. To cover some more cases. So be on the lookout. If you guys are not subscribed, and make sure you do subscribe so that you don't miss any more coverage of these cases. And I will see y'all all on the next live stream. Bye.